Okay, so Rule 120 is about judgment. What is a judgment? That is defined under Section 1 of this rule. Judgment is the adjudication by the court that the accused is guilty or not guilty of the offense charge and the imposition on him the proper penalty and civil liability, if any. It must be written in the official language, personally and directly prepared by the judge, signed by him, and shall contain clearly and distinctly a statement of facts and the law upon which it is based. So the requisites, it must be in writing. Second, it must be directly and personally prepared by the judge. And third, it must be signed by him. Fourth, it must clearly and distinctly state the facts and the law to which upon which it is based, and it must be filed with the clerk of court. Yan. So, the contents of the judgment. Ay, before that, meron tayong tinatawag na sin, perjuicio, judgment. So, that judgment is void because the facts and the law stated, but that because there are facts and law stated, but the facts are not established by evidence or wrong law was relied upon, the judgment is valid and the remedy is appeal. That is error of judgment. If no facts and law is stated, even if the judgment is correct, the judgment is void and the remedy is petition for certiorari. That is error of jurisdiction. Ano daw? Bakit ko sinabi yun? Sin perjuicio judgment is a void judgment. So, yun ay yung mga hindi nag-comply sa mga to, sa mga requisites. So, ano pa ba? Okay. Section 2. Contents of judgment. So, if the judgment is of conviction, it shall state the legal qualification of the offense constituted by acts committed by the accused and the aggravating or mitigating circumstances which attended the commission, the participation of the accused in the offense, whether as principal, accomplice, accessory, after the fact, the penalty imposed upon the accused, the civil liability or damages, if any. Yan. In case of the judgment is of acquittal, and it shall state whether the evidence of the prosecution absolutely failed to prove the guilt of the accused or merely failed to prove his guilt beyond reasonable doubt. In either case, the judgment shall determine if the act or omission from which the civil liability might arise did not exist. Section 3. When there are two or more offenses. So, when two or more offenses are charged in a single complaint or information but the accused fails to object, kasi diba bawal yan? Bawal ang two or more. Pwede ang motion to quash dyan. Yan. Pero kung the accused fails to object before trial, the court may convict him as many offenses as charged and proved, and impose on him penalty for each offense, setting out separately the findings of fact and law in each offense. In Section 4, judgment in case of variance between the allegation and proof. So when there is variance between the offense charged in the complaint or information and that proof, the offense as charged is included in or necessarily includes the offense proved, the accused shall be convicted of the offense proved, which is included in the offense charge, or of the offense charge which is included in the offense proved. So when the offense includes or is included in another, an offense charge necessarily includes the offense proved when some of the essential elements or ingredients of the former, as alleged in the complaint or information, constitute the latter, and an offense charge is necessarily included in the offense proved when the essential ingredients of the former constitute or form part of those constituting the latter. So, promulgation of judgment. Section 6. And the judgment is promulgated by reading it in the presence of the accused and any judge of court in which it was rendered. However, if the conviction is for a light offense, the judgment may be pronounced in the presence of his counsel or representative. When the judge is absent or outside the province or city, the judgment may be promulgated by the clerk of court. If the accused is confined or detained in another province or city, the judgment may be promulgated by the executive judge of the RTC, having jurisdiction of the place of confinement or detention upon request of the court which rendered the judgment. The court promulgating the judgment shall have authority to accept the notice of appeal and to approve bail pending appeal, provided that if the decision of the trial court convicting the accused change the nature of the offense from non-bailable to bailable, the application for bail can only be filed and resolved by the appellate court. The clerk, the proper clerk of court shall give notice to the accused personally or through his bondsman or warden and counsel, requiring him to be present at the promulgation of the decision. If the accused tried in abs is tried in absentia because he jumped bail or escaped from prison, the notice to him shall be served in his last known address. In case the accused fails to appear at the scheduled date of promulgation of judgment despite notice, the promulgation shall be made by recording the judgment in the criminal docket and serving him a copy thereof at his last known address or through his counsel. If the judgment is for conviction and the failure of the accused to appear was without justifiable cause, he shall lose all remedies available in these rules against the judgment, and the court shall order his arrest. Within 15 days from the promulgation of the judgment, however, the accused may surrender and file a motion for leave of court to avail these remedies. He shall state the reasons for his absence at the scheduled promulgation, and if he proves that his absence was justifiable cause, he shall be allowed to avail said remedies within 15 days from notice. So, yun, may the judgment be promulgated in absentia, pwede, provided that the accused was notified of the date and time of the promulgation but he still failed to appear. So, if it is promulgated in absentia, ano ang gagawin? Ano sabi dyan? It will be recorded. Ayun. It shall be recorded in the criminal docket and serve him a copy thereof at his last known address or through his counsel. If the judgment is promulgated in absentia and the accused is convicted, the court will issue an arrest. And if he is under bail, the bail will be cancelled and an arrest will be ordered. And so, kung if the judgment was promulgated in absentia, he loses all his remedies, no? Andito yan. He loses all his remedies like appeal, motion for reconsideration, or motion for new trial. So, anong gagawin niya? No? Within 15 days from the promulgation of judgment, he shall surrender and file a motion for leave of court to avail those remedies that he lost and state the reasons for his absence during the promulgation of the judgment, and that if he proves that his absence was justifiable, he shall be allowed to appeal said remedies within 15 days from the notice. Okay, so I had to go back dun sa requisites for a judgment, no? Aside from it must be in writing, prepared directly and personally by the judge, designed by him. It states the facts and law upon which it is based and filed with the clerk of court. The judgment shall be promulgated during the incumbency of the judge. So, kailan ba nagiging hindi na incumbent? Hindi na incumbent si judge or he ceases to be an incumbent judge if he dies, he is dismissed, he is appointed to another office, or if he resigns, no? So, yun. Pwede tayong bumalik sa baba. Ayan. So, modification of judgment. So, a judgment of conviction may, upon motion of the accused, be modified or set aside before it becomes final or before appeal is perfected, except where the death penalty is imposed. A judgment becomes final after the lapse of the period for perfecting ang appeal, or when the sentence has been partially or totally satisfied or served, or when the accused has waived in writing his right uh, to appeal or has applied for probation. Yeah. So entry of judgment. After the judgment has become final, it shall be entered in accordance to Rule 36. And Section 9, the last section for Rule 120, existing provisions governing suspension of sentence, probation, and parole not affected by this rule. So nothing in this rule shall affect any existing provisions in the laws governing suspension of sentence, probation, and parole. Okay, so that ends Rule 120.